Welcome to a practicePRO CPD, brought to you by LAWPRO.
Hi, I'm Juda, Strawczynski, Director of practicePRO, LAWPRO's Claims Prevention Program. Thanks for joining me for this talk on common claims and tips to avoid them. In this section, we'll review the common claims that are reported by lawyers to LAWPRO. We'll drill down into the types of claims by example to get a better understanding of the types of errors that we see. Based on that, we'll provide tips for how you can avoid your risk of such claims. Finally, we'll provide resources to help you on your way. So first, let's debunk a key myth. There's a myth out there that only bad lawyers make mistakes, only bad lawyers get sued, only bad lawyers end up with claims against them or have to make that call to LAWPRO and report a matter. And the fact is, that's just not true. Even the best lawyers have made mistakes. And statistically, over 40% of lawyers have or have had a claim that they have had to report to LAWPRO. So this is just part of the modern practice of law. Either mistakes happen or there may be issues on a file where you might get sued or where someone might complain about you even though there's no merit. So there is no shame in reporting, and in fact, this type of report can happen to anyone. We're data-driven, and the general claim statistics are quite revealing. First, it's interesting to see when claims are reported. They're typically reported 2 to 3 years after the service is provided, although we do have the occasional claim that's come in literally decades after the service was provided. So there are outlier files, but typically it takes a few years before someone is going to report an issue with the delivery of services. Most claims occur to lawyers who are in the 6 to 25-year range of practice, which helps to explain why we can provide a new lawyer discount. At a claims basis, there are fewer claims and less risk from lawyers in that first 1 to 4 year range. Although, of course, junior lawyers are also still at risk of making mistakes and needing to report to LAWPRO, the severity on average is less than in the 6 to 25 year range. Generally speaking, we don't see claim sensitivity by geography. We sometimes have people assume that Bay Street is subsidizing the rest of Ontario lawyers or vice versa. Bay Street is subsidizing Main Street. Main Street is subsidizing Bay Street. In fact, that's not the case. We see no claim sensitivity by geographical region. Now let's look at the types of claims that we see. For 2009 to 2019, communication errors were the single biggest issue across the board. The closely related top three are communication, time management, and inadequate investigation. Inadequate investigation at times is caused by communication breakdowns. Time management is related because if you're pressed for time, you may not be taking the necessary time to learn a case or communicating back to a client and learning more as you go. Interestingly, error of law accounts for about 14% of the claims. Now, when we look at the totals by cost, there's a slight shift. So the previous slide looked at the totals by number. This is the cost by claim. And you'll see that communication is about a third of the cost, time management 15%, investigation errors 18%, and error of law does creep up slightly to 18%. Bottom line though, the top four are communication, time management, inadequate investigation, which are all service-related errors, and error of law rounding out the top. There's some significant variation though by practice area. In litigation, time management becomes by far the most significant issue, particularly if you're the plaintiff. Our courts are process-driven. Our advocacy relies on the effective moving of files. Time management becomes the number one concern for plaintiffs' counsel because it's up to plaintiffs to move their files forward, to make sure that their client's claim is moving along, be it at a court or an administrative tribunal. And if there are deadlines that are missed, that will be a time management error. Communications, inadequate investigation, and error of law continue to round out the top 4. On defense side, time management is still a significant issue, as is communication and inadequate investigation. On the defense side, for example, if someone misses a limitation period in claiming over against a third party, then that would be a time management issue. And we see this happen from time to time, where someone might sue a defendant, and you might act for the defendant and defend and start to move this action forward. And only after a significant passage of time, upon further reflection, realize that maybe there were others who could be held responsible who aren't yet in the action. But by the time you figured that out, it's too late.
Real estate claims are the number 2 area by cost and the number 2 area of claims at LAWPRO. You can see here that communications and inadequate investigation are the most significant risks. Interestingly, time management nearly drops off the map, and that's likely because real estate lawyers can work together with clients to make sure that the timelines are reasonable and there's usually sufficient time for a deal to close. Communications errors are varied, but include things like not inquiring about a client's intentions for future use of a property. You can imagine how frustrated a client who dreams of having an outdoor pool would be if they try to build that pool only to find out that they're not permitted to do so. Failing to inform a client about restrictions on land use is a pretty significant error that we see under communications. Inadequate investigation includes things like misreading a survey or simply not asking for the survey in the first place. Sometimes it involves things like not investigating parking spots or locker space on a condo to make sure that they're included in the purchase and that they're properly described. For your client, there could be nothing as bad as driving into a parking spot they think they own, only to discover that it's in fact their neighbor's. Error of law in this area remains at about 6%. There are a range of errors that can occur in the course of the transaction. Real estate includes tax, it includes planning use, it includes a wide range of law, and so error of law remains in the top 4, together with clerical errors, given the use of clerks for many of the searches and their responsibility to gather documentation. Clerks will often be asked to pull registry information as well as surveys or other vital information, which ultimately the lawyer must review and supervise.
In corporate law, again, the key here, again, is communications. Time management, less of an issue. These are typically well-driven transactions and ones that where there can be flexibility from time to time on some of the core pieces. But it's the communications, the misunderstandings along the way that become significant. And not fully understanding the transaction clearly in second at 18% is a significant piece as well. Family law is interesting because family law is at times high conflict area. It is a difficult area. It is a complex area. And that complexity is reflected in a spike in the error of law claims. You'll see it's up to 22% here. And that's because family law touches on all sorts of areas of law. A full family law matter might be requiring the attention of both a superior court and the Ontario Court of Justice. In some jurisdictions, there are unified courts that can hear both of those at the same time, but that's not always the case. Family law can touch on children's rights, property, assets, division of property. It can talk about tax implications, and it's also known as forever law because what might be true for separation today might need to be revisited down the road. For example, when kids turn the age of a majority or when somebody is retiring and a pension kicks in. And so it's fairly complicated as a substantive area. It's also a challenging area because of the conflict, and there are many risks for communication errors with clients as you move through a file. Wills and estates is another area that is vital to clients, vital to the public, and here too, communications is a key, but it's inadequate investigation that is the significant piece. And that really goes to not knowing what your client is hoping to establish. What is their intention? Why did they come to you for a will? What kind of estate, what kind of legacy do they want to leave behind? And that requires some real digging and some real questioning of why the client is there, what kind of assets they have, what kind of structure they are looking to leave behind for their heirs. And at times, that requires more time than lawyers have set aside for intake meetings. And it really does require further follow up so that the lawyer can best reflect the client's intentions. Intellectual property is another interesting one, and this one you'll see on the pie chart is different from anything we've seen so far. You'll see that clerical errors are the number one issue. And that's mostly because intellectual property, while a fascinating area of practice, from a risk management perspective, most of the errors aren't really about the error of law, it's about clerical errors. It's about, for example, misfiling documents, missing key correspondence, filing at the wrong office, not receiving correspondence from a foreign patent agent at the right time and failing to follow up. Basic clerical tasks, but where they are dropped, the risk can be significant to somebody's intellectual property rights. And so here, clerical error is a significant issue. Time management is a related matter, and communication still rounding out the top. So let's talk a bit about some of the specific claims risks. As we've seen from the slides, communication errors are significant. There are a range of different communication mistakes that can happen along the way. One is the failure to follow your own client's instructions. We see this, for example, in wills, where a client and the lawyer will sit down and talk about the client's intentions. But then when the lawyer goes to draft the will, at times the client's instructions are forgotten or omitted in the drafting process. This is at times because the lawyer has failed to properly reflect on their client's instructions, even though they're right there in writing for the lawyer to review. The failure to obtain consent or inform a client of key steps is another error that we see. This can be pretty significant. For example, we've seen litigation commenced on behalf of a client without that client's consent. That sort of situation is very shocking for clients. At times, the poor communication is more general. It's more of a pattern, a death by a thousand cuts, rather than one significant issue. When communication is irregular, or where the communication actually doesn't provide helpful updates for a client, it can lead to the client losing faith in the lawyer and possibly the end of a lawyer-client relationship. Often communication issues will turn on credibility, and at trial, it can turn into a he said, she said, where without contemporaneous written evidence, without documentation, it strictly becomes a matter of credibility between client and lawyer. When in front of a court, a lawyer without notes, even though you're an officer of the court, even though you're well-intentioned, your evidence might not be preferred. In fact, it's likely the client's evidence that would win the day. As a lawyer, you're going to sit down with hundreds of clients. It's going to be hard for you without those documents to remember the specifics of in-person meetings. Your client, though, will have had fewer of such meetings. This might be the only time they meet with a lawyer. Your client will have very specific recollections of what was said. Not just what was said, but other micro details that will enhance credibility. Things like how long the meeting lasted, whether you were on time for the meeting, the type of room you met in, whether they were served coffee, whether the coffee was drinkable, how many people were in the room, whether you were taking notes at the time. They will remember the details far better than most lawyers will in that same situation. And so all the more reason to keep detailed contemporaneous notes or to confirm your instructions in writing as soon as possible thereafter. We talked about time and calendaring. I threw a few examples along the way, but a missed limitation period is one of those fatal ones that becomes quite significant in the life of plaintiff lawyers in particular, but occasionally for defense as well, such as when they want to tag others into the litigation. Not having a tickler system, not having a calendar system in place can be a real problem for lawyers in practice. There are all sorts of tools that can help you guide your calendaring and make sure that you're on task and not missing deadlines as they approach, be it for making sure that a litigation matter is proceeding in a timely manner or making sure that a real estate deal closes on time. Sometimes you've got a calendar system, but people aren't paying attention to it. I've pressed dismiss countless times on meeting reminders, and so the key really is to strike that balance between nudges that are helpful and just ignoring. And procrastination or lack of follow-up is another one, and we have separate presentations we give about time management because often the error is just not doing the work as promised on a timely basis or where you haven't followed up with your client or have received instructions but didn't take the next step. And a lot of that, there's some unpacking around procrastination. Oftentimes, and as I mentioned, we've got full presentations on this, but oftentimes procrastination is about an underlying anxiety that a lawyer might have about not quite understanding what they're supposed to be producing or worried that they might not do it well enough. Certainly at the junior level, we've seen clusters of claims where an associate might believe that they're not able to deliver and sit on the problem, as opposed to coming forward and asking for assistance or asking for clarity. We also have cases where the procrastination is probably due to task averseness, and that's where people simply don't want to do the work because they don't like it. And I sympathize. There are many parts of life that people don't like to do, but it's like in The Little Prince where they've got that tree and the prince goes and takes care of it every day and benefits from it. It's a one day at a time thing. Some of these things just need to push through to get done. We've talked a lot about inadequate discovery or investigation of facts, and the bottom line is that's not digging deep enough. So, another few examples would be not doing searches on a commercial lease and not figuring out what's already registered on a property, what sort of other interests might exist, or on a personal injury matter, if you have forgotten to ask for hospital records or for medical records, or you have not asked if there is a police record. You might end up at a trial where your client says, I turned left, and a police officer is there based on recollection and on their notes that were taken the day of the accident will say, no, according to all the witnesses, they turned right. That would be a significant issue for you to find out on the eve of trial. So we don't like being surprised. There's a reason we don't like trial by ambush. And so it's up to you to make sure that you've got everything you need to understand a case. And if your client hasn't given you everything that you think you need to think about how to have those conversations with your client as well. So failing to know and apply the law is a significant risk. It's in the top four, although, as mentioned, it's about 14% of total claims, 18% of our cost on claims. And the law is fluid, as you know. There's new legislation every day, new regulations. Gillian Hadfield, the professor at University of Toronto, talks about how we live in a law-thick world. We are from morning till night, our activities are guided by laws and regulations, and then we have case law that informs that as well. And so as lawyers, there is no shortage of laws to study and updates to stay on top of. Finally, on clerical and delegation errors, as we saw in the intellectual property sphere, these can be significant errors that cause real harm, and they're usually simply human error. Things like misfiling documents, typos in forms, mistakes in form completion, missing steps in proceeding are all errors that ultimately you as the supervising lawyer would be responsible for. And part of this goes to the lawyer as manager. Lawyers supervise associates, supervise clerks, supervise teams, depending on the practice setting. And a lack of supervision or poor delegation can contribute or cause the error. So it's important to learn the managerial skills for managing people. And with respect to delegation, there are quick, simple, teachable pieces like giving clear instructions, diarizing for feedback, and reviewing work once it comes in. There are entire courses available about how to manage staff or to supervise, but the bottom line here is that mistakes can happen and do happen with clerks, And as lawyers, it's up to us to properly delegate, supervise, and be responsible for the quality of our products. Conflicts of interest, you may have seen, was in most of the pie charts we looked at earlier. There are all sorts of areas in law where lawyers may be precluded from acting or where there may be conflicts that have to be addressed before they are able to act. And there are different types of conflicts, and you may have come across some of the leading cases already. But acting for a new client against a previous client can be a significant issue. In family law, there are issues about which family person you represent. For closely held corporations, this question comes up all the time. Am I acting for the company or for the person who is directing me, or for directors or for shareholders? And so wherever you're acting, it's important to know who is your client. And that sounds basic, but in some cases, it really needs to be set early and made clear, because that might not be clear to your clients even. Then there's investing in clients, and we do see this sometimes. We see where there are fees or where there are innovative fee structures, but where independent legal advice might be necessary to protect everyone before you proceed in that more entrepreneurial way of providing services while investing in a client. So conflicts of interest always have to be one of the things that lawyers, be they in a firm or in a solo environment, you have to be aware of those potential risks, and there are tools to help to screen against them. We sometimes see people bending to try to help particular clients. We call this the big client error. It's not really big in terms of size necessarily. It could be a big anchor client who is covering a lot of your overhead and your livelihood. But at times, the big client is really a larger than life type of character, or someone who is weighing on you and taking more energy than others because of how they are working through with you or the nature of their situation. And it's really important to make sure that you treat that big client as you would any client, and not cut corners or take shortcuts or overlook conflicts of interest or take steps because of client pressure that you otherwise normally would never take. Now, we all try to avoid conflict. It's human nature. And so we're all driven to try to please clients, and there may be an incentive in trying to take a shortcut or in trying to do something quickly so that you can move on, or to perhaps make sure that you don't end up out your legal fees at the end of the day. There are lots of reasons why people move to potentially accommodate the quote unquote big client. But it's important to keep in mind that those sorts of practices can haunt you in the longer term with a claim down the road. And so it's important not to just accommodate asks that are unreasonable or to take steps that would be imprudent for other clients. Another pressure point is around fees. One of the issues that we sometimes get pretty uncomfortable talking about is money. Regardless of how you bill or what fee structure you've agreed to with your client, fee disputes are a risk for lawyers in private practice. And so it's vital to manage expectations from the start. It's important to bill on an ongoing manner unless you're in a structure that doesn't require it. And that requires getting sufficient funds at the start, and to bill regularly and ask for further funds to replenish your retainer should you be low on funds. If a client's having troubles paying, in some cases, that may mean that you would wish, understandably, to stop acting for that client. And there are cases where it is entirely understandable that you would seek to no longer be the lawyer of record for a particular client. And you're entitled to stop in many cases, but you must consider the rules of professional conduct that apply and the client's unique situation to make sure that doing so would be reasonable and permitted. Finally, we recommend that lawyers not sue their clients for outstanding fees. Suing a client often leads to a counterclaim where the client alleges negligence on your account, and that leads to protracted litigation. So be careful when dealing with fees with clients and make sure to get a common understanding at the outset. Let's go over some helpful tips to help you manage your risk. So the first part is, if you want to avoid a malpractice claim, be prepared. Take your time, do the homework. That sounds simple, but in a really busy practice, that can be hard to achieve. The key is to not rush. It's important to not take shortcuts at any stage. And you really need to be asking yourself always from the service perspective, what is it that the client's here for? What is it that they're looking for? And at times, that requires some reading between the lines because there may be emotional background that you might not necessarily see on a first meeting, but that might be driving the decisions. And there may be differences between what is their position that they tell you about at a first meeting and what their true interest is. And as the person who's helping them navigate their legal rights and their legal options, it's important to be able to distinguish between the two and help the client understand what it is that they're really looking for as a solution, which means backing up and really understanding what their problem is, which may not strictly just be about the law. It's also important to really understand whether there's anything unusual in a transaction and why that might be the case. If there's something that doesn't add up, it's imperative that you ask. You need to ask and ask and ask to really understand why somebody is in your office, why you're meeting with someone, because it's possible that somebody is trying to use you for reasons that have nothing to do with an actual legal issue and all about trying to either take you or others for a ride. So at the end of the day, doing good work is the key always, and that involves preparation. The litigators who are the stars, the rainmakers in corporate law, it didn't start from where you see them. It started by preparing meticulously and moving forward with their career by setting good habits early. So if you're a litigator, it means putting in your case properly. If it's in the corporate commercial transaction or real estate, it means doing the due diligence properly that you have been retained to do. So do good work, be proud of your work, and that will help build your reputation and your confidence and your ability to take on more complex work over time. Client management, as you've seen from the communication pie charts, client management is key. You can set the tone from the start, from the very first time you meet a client. It's an opportunity to learn. It's also an opportunity to explain to the client what the professional relationship will look like, what the expectations will be for a healthy working professional relationship, and to ensure that you will be communicating regularly with your clients throughout their matters. It's also important not to tolerate inappropriate behavior. Particularly more junior lawyers at times get berated by clients. It's been known to happen. On occasion, somebody will feel like because they are paying you, they own you. That is simply not how a professional relationship works. At times, you'll be pressured and asked to do things or to not do things in ways that make you uncomfortable. And those are telltale signs that someone is trying to take advantage of you for reasons that likely have nothing to do with your professional conduct. So it's important to know when to say goodbye. It's also really important to know how to say goodbye. There are times in a relationship where you simply cannot. If you are on the eve of a trial, for example, it is highly unlikely that a court would let you get off the record, and that is a matter that you would have to be mindful of when considering when you might want or need to end a relationship. I mentioned the paper trail, and it's really vital. It's really vital to get confirmed instructions in writing on all key decisions. This doesn't have to be a big thing. It can be an email confirmation back from a client. Hi, client, we met today. Thanks for coming into my office. We discussed A and B. You decided that on my advice, we should go ahead with X. Can you please confirm and I will start drafting? And when they write back and say green light, you've got what you need. It's important to keep things written because it helps you keep track of where you are in the process, in the time frame, in what your next steps ought to be. It's also very helpful at key points in the litigation or in a transaction to keep things in writing so that there is a record. So that if, for example, there are written offers to settle that are going back and forth in a dispute, that you're writing to your client and letting them know about the offer, and they're writing back about questions they may have, or you're confirming in writing when they've accepted. and explaining the terms in writing again so that it is clear that they understand what they're getting into. Same idea on a corporate commercial transaction, where if there are offers back and forth on a house, for example, or if there are offers back and forth around a merger, everyone is on the same page as to where things stand and what are the next steps. So it's great. We love to see detailed dockets, detailed notes to file, detailed emails or formal letters back to clients. And of course, for the retainer itself from the outset, you can define the scope of the engagement, and then when the retainer is over, a final letter to end the engagement is always a beautiful thing to see. Of course, on that point, you'll sometimes meet clients, prospective clients, who will show up, who you may sit down with, you may meet, and there may be a conflict, or they may decide not to work with you, or you may decide that you simply cannot do what they are seeking because it's not within your area of expertise, or because their approach does not align with your recommended approach and you don't want to take the case forward. In cases where you're not going to continue on, it's always helpful to confirm back to that prospective client in writing that you are not their lawyer, that you are not acting for them, and that there is no solicitor-client relationship. This presentation shows that claims are real and preventable. Most claims, in fact, relate to service issues around communication with clients, around understanding their cases, and managing deadlines. Although there are claims related to misapplying the law to a client's situation, most claims, in fact, relate to the service element of the practice of law. It's important to recognize and understand the risks in private practice in order to be able to be proactive to lower your risks. Thankfully, practice supports are available at practicePRO.ca and through our Avoid a Claim blog. We're here to help. To learn more, here are a few additional resources. Of course, there's practicePRO.ca. You can learn more about issues such as COVID-19. We've got continuing professional development, practice aids. All of the LAWPRO magazines are available from this site, as well as other helpful resources, including template retainer letters and our managing series booklets. You can also find LawPro's malpractice claims fact sheets at practicePRO.ca. These have recently been updated to review common claims by area of law, the risks by area of law, and tips so that you can reduce your risks as you practice. AvoidAClaim.com has the latest news on claims prevention and practice management. It also has fraud warnings and descriptions of the common frauds that lawyers see. You can subscribe for updates right at AvoidAClaim.com in the top right. Thanks very much for watching. Feel free to connect with me personally and follow LawPro and practicePRO on Twitter. LawPro also is on LinkedIn. We look forward to staying in touch. Thanks very much.